If you came into the United States on ESTA, you fell in love, you married a U.S. citizen, and you're thinking, great, I'll go to the marriage green card interview and walk out approved. I need you to understand something clearly. In 2026, that interview can become the day you're escorted out and put on a plane, and you might not even get the chance to appear before an immigration judge to fight your case. A lot of people hear visa waiver program and assume it's simply an easier way to travel. No consular appointment, no visa interview, no thick file of paperwork to get a visa stamp in your passport. You apply for ESTA online, get authorization, board your flight, and enter the US. It feels simple, it feels welcoming, it feels like you're being treated as a low-risk traveler. And many times it is easy, but that word waiver is doing more than people realize. It isn't only waiving the requirement to get a visa. In many cases, it also means you're waiving rights that visa holders usually have when the US government decides it wants you out of the country. To keep this simple, let's compare two people. I'll call them Elvis and Victor. Elvis enters the United States on ESTA through the Visa Waiver Program. Victor enters the United States on a regular non-immigrant visa, like a B1, B2 visitor visa, or maybe a student visa. Both enter lawfully. Both are inspected at the airport. Both are legally in the U.S. the moment they're admitted. Now, Elvis and Victor each meet a U.S. citizen, fall in love, and get married. Both decide to apply for a marriage-based green card from inside the United States. Both think, we're married to a U.S. citizen. That's an immediate relative case. What could possibly go wrong? Oh, here's what could go wrong. The process is not the same, and the protections are not the same. And that difference can change everything. When you enter on ESTA, you're typically admitted for up to 90 days. There's no extension. There's no change of status. The government's expectation is that you're coming temporarily, leaving quickly, and not trying to turn that trip into permanent residence. That doesn't mean people never adjust status from ESTA. People do. Immediate relatives of U.S. citizens can often file adjustment of status, even with overstays, and many cases are approved. But the real issue isn't just whether you can file. The real issue is what happens if the government doesn't like something about your case, and what happens if they decide to enforce the rules in the harshest way. Here's the critical legal reality. With visa waiver entry, you are generally giving up the right to fight removal in front of an immigration judge, with very limited exceptions. Most visa holders, if the government wants them removed, are placed into removal proceedings. They get a notice to appear. They get a hearing date. They get to stand before a judge and ask for relief, ask for time, show that they have a path forward, request bond in many cases, have a lawyer argue for them, and have a decision maker outside the enforcement agencies decide what happens. That's Victor's world. Elvis's world can be very different. If DHS decides Elvis is removable, removal can happen quickly. And the normal path to an immigration judge often isn't there the way people assume it will be. That's why this matters so much in 2026. Because we're seeing reports of more aggressive enforcement in certain situations, including cases where someone shows up for a government appointment thinking it's just paperwork, and the government uses that moment to take enforcement action. So here's how this can look in real life. Elvis enters on ESTA, gets 90 days, meets a U.S. citizen partner, gets married, and files the I-130 and I-485 package. Maybe within the 90 days, or maybe shortly after the 90 days expires. They may have good intentions. The marriage may be real. The evidence may be strong. The case might be fully approvable, but at the interview, USCIS is not required to approve on the spot. USCIS can continue the case. USCIS can issue a request for evidence. USCIS can separate the couple. USCIS can focus hard on intent. USCIS can suspect fraud even when there's no fraud. USCIS can decide there's misrepresentation. USCIS can find an old record. USCIS can think the evidence is weak. USCIS can say the medical is wrong. USCIS can raise concerns about prior travel, prior overstays, or prior entries. USCIS can decide immigrant intent was present at entry, And if USCIS denies Elvis and DHS decides to take enforcement action, Elvis may not have the same procedural runway that Victor has. Victor, the visa holder, can also have problems at an interview. Victor can be denied. Victor can be arrested. Victor can be referred to ICE. That can happen. But Victor usually has something Elvis often doesn't: a system where the government issues charging documents and a judge becomes part of the process. Victor can often request bond. Victor can fight while the I-130 is pending or after approval. Victor can ask the judge for time. Victor can show eligibility for adjustment. Victor can argue discretion and equities. Victor can have a lawyer litigate in immigration court. Is that easy? No, it's stressful, but it's a process with time, steps, and a judge outside the enforcement agencies. Elvis on ESTA can be treated like someone who already agreed in writing that if the government decides he has to go, he goes, without the typical court hearing people expect. And once DHS is in that mode, things can move fast. That's the nightmare. You show up expecting a marriage interview, and it becomes an enforcement event. Now, some people will say, but I know someone who entered on ESTA and adjusted status, and everything was fine. Yes, that happens all the time. Many STA adjustment cases get approved. The point is not that every STA case ends badly. The point is that when an STA case goes wrong, it can go wrong faster and with fewer guardrails than a typical visa holder case. So what is the most dangerous moment? It's not marriage itself. It's not even just filing itself. The danger moment is when you place yourself somewhere the government has both the information and the opportunity to act immediately. The marriage interview is one of those moments. You're in a federal building. You're identified. Your immigration history is in the file. Your fingerprints are in the system. The government can decide and act right then. If you're Victor and something goes wrong, the common path is removal proceedings, where you may still be able to fight and ask a judge for time to pursue the green card process. If you're Elvis, the STA entrant, DHS can decide you're done, and you may not get the same chance to slow the train down. And then there's the painful part. What happens after removal? Many people don't realize how quickly one bad day can become years of separation. Different bars can apply depending on facts, and details matter. One major set of bars involves unlawful presence. If you accrue more than 180 days but less than 1 year of unlawful presence and then leave the U.S., you can trigger a 3-year bar. If you accrue 1 year or more and then leave, you can trigger a 10-year bar. Those usually trigger when you depart. Then there can be additional penalties when the government removes you, especially through fast-track processes or if fraud or misrepresentation is alleged. Some removal mechanisms carry their own multi-year bars, and the length depends on the type of removal and the allegations involved. The point isn't to memorize numbers from a video. The point is, once DHS removes you rather than you leaving on your own timeline, you may face serious reentry consequences, layered on top of unlawful presence issues. That's how a marriage case you thought was straightforward turns into long-term separation and a complicated waiver situation. That's why you should stop thinking of ESTA as just visitor entry. You need to think of ESTA as visitor entry where you gave up major procedural protections if the government later decides to remove you. Now let's talk about timing and intent, because this confuses a lot of people. Couples meet, things move fast, they get engaged, they get married. Life happens, love happens, and the law does not say you cannot fall in love during a trip. The law does not say you cannot marry after entry, but the government cares about intent at the time you entered. If someone enters on ESTA saying, "I'm just visiting," while secretly planning to stay permanently and file for a green card, the government can treat that as misrepresentation. That creates a separate layer of risk, including inadmissibility and possibly a waiver requirement. Intent is difficult because it's about what was in your mind at entry. The government often tries to infer intent from timelines, messages, wedding planning, and other evidence. Questions like, did you plan this before you entered? Did you have a return ticket? Did you quit your job back home? Did you ship belongings? Did you tell people you were moving? Were you engaged already? Did you come to marry and stay? Many real couples can answer those questions in a way that shows plans changed after entry and the relationship developed naturally. But the shorter the timeline, the more scrutiny you should expect, and the more careful you should be about getting competent legal advice before filing. And this brings us back to Victor. Victor can have intent issues too, but if the government challenges him, Victor's procedural protections are usually stronger than Elvis's. So, what do you do with this information? First, if you are overseas and thinking, I'll use ESTA to enter, marry my U.S. citizen fiancé EE, and then stay and file, slow down and talk to a lawyer before you do that. I'm not saying it can't be done. I'm saying you should not treat it like a casual plan because the downside risk can be severe. Second, if you're already in the U.S. on ESTA and married to a U.S. citizen, you need to understand that strategy matters. When you file, how strong the evidence is, what your immigration history looks like, what your travel history looks like, whether you have arrests, prior overstays, prior denials, any issue that could cause USCIS to hesitate or deny matters. A clean, well-documented case with real evidence and no intent red flags is not the same as a case with mixed facts, weak documentation, inconsistent timelines, or past immigration problems. Third, consider whether consular processing is safer for you. Consular processing means you file the I-130, get it approved, then complete the immigrant visa process through a U.S. consulate abroad, and enter as a lawful permanent resident. For many couples, it's emotionally harder because it can require time apart. But from a risk management perspective, in some cases, consular processing is the safer choice, especially if filing inside the U.S. could expose the immigrant spouse to rapid removal if the case is denied or enforcement is triggered. And yes, some people think, but if I leave, I might trigger a 3-year bar or a 10-year bar. Exactly. That's why this is not one size fits all. You need individualized legal advice. Some people choose filing inside the U.S. because they're afraid of triggering a bar by leaving. But if filing inside carries a meaningful risk of removal and other penalties anyway, you have to compare those risks honestly, not emotionally. There's also something people misunderstand. Filing for a green card does not automatically protect you from enforcement in every situation. People think filing is a shield. In many cases, it helps because it shows a pathway and a benefits process is pending. But filing doesn't erase how you entered, what rights you waived, or what DHS can do if they decide to act. So imagine 2 interview days. Victor walks into the interview. The officer questions, reviews, maybe approves. Great. But if the officer doesn't approve, Victor might be denied, referred to ICE, even detained. But often Victor is put into removal proceedings where his lawyer can ask the judge for time, can argue bond, can keep the case alive and fight. There's a process. Elvis walks into the interview. Same setup. But if the officer denies or decides Elvis is removable, Elvis may not get that runway. Elvis might not walk out the front door. Elvis might be taken into custody and moved quickly. Elvis might not get a future court date. Elvis might not have the same path to bond. Elvis's family may be calling lawyers after the fact, trying to find him and trying to stop a removal that is already in motion. Is it guaranteed? No. Is it possible? Yes. And in 2026, it's a possibility you have to take seriously if you entered on ESTA. People ask, can a lawyer stop it? Sometimes, but it's difficult. Lawyers sometimes talk about filing an emergency habeas petition in federal court, asking a federal judge to intervene. That's not normal in most marriage cases. It's extraordinary. It's expensive. It's fast-moving. It depends on the facts, the timing, and the jurisdiction. And the biggest issue is the clock. If DHS moves quickly, you may be racing the plane. No responsible lawyer should promise that federal court will swoop in and fix everything. The goal is to avoid needing that kind of emergency rescue in the first place. So here's what you should take away. If you're a U.S. citizen dating or married to someone who entered on ESTA, understand your spouse may be more vulnerable than you realize. That vulnerability isn't about whether your marriage is real. It's about the procedural protections they gave up when they entered under visa waiver. If you are the immigrant spouse who entered on ESTA, understand you're in a category that can be deceptively risky. STA is easy until it isn't, and when it isn't, the consequences can be immediate. And if you're overseas thinking about using ESTA as your pathway into a marriage green card, treat that as a serious legal decision, not a travel decision. The difference between entering on a visa versus entering on ESTA can be the difference between if something goes wrong, I get to argue my case in court, and if something goes wrong, I might be gone before I can even explain. None of this is meant to scare you into doing nothing. Doing nothing is often the worst plan. Overstaying without a strategy, without a filing plan, without legal advice, without understanding consequences, that's how people fall into the worst outcomes. The goal isn't fear. The goal is informed decision-making. Sometimes the right move is filing adjustment quickly with a well-prepared package, strong evidence, and a clear explanation of the timeline, especially when the facts are clean. Sometimes the right move is consular processing, especially if there are risk factors like prior immigration issues, questionable intent evidence, prior denials, or anything that could trigger a denial and enforcement action. Sometimes the right move is getting legal advice before anyone travels, before anyone marries, before anyone files. Because once you file and once you show up to that interview, certain things are already in motion. And I want to underline this. USCIS doesn't have to think your case is bad the way you think bad. USCIS can deny for technical reasons. USCIS can deny for missing documents. USCIS can deny for inconsistent answers. USCIS can deny over legal interpretation. USCIS can deny due to suspected misrepresentation. USCIS can deny because they don't believe the marriage is bona fide. USCIS can deny because they think you're inadmissible for a reason you didn't even know existed. In a visa holder case, a denial is devastating, but often there's still a procedural path to fight. In an ESTA case, a denial can be the start of a fast enforcement chain. And if you're wondering why the government would do this to someone married to a U.S. citizen, remember, marriage to a U.S. citizen is a powerful basis for immigration benefits, but it's not an immunity shield. The government still enforces immigration laws, investigates fraud, applies inadmissibility rules, uses discretion, and coordinates within DHS. And the visa waiver program is designed in part to allow faster removals when DHS believes someone violated the terms of admission,